The inalienable rights of the Palestinian people for convening this meeting and having me prepare remarks for you, as well as the Division for Palestinian Rights, who are the engine behind it all. Thank you very much. I have been requested to address some of the available international and domestic legal strategies for addressing the issue of Israeli settlements in occupied Palestine. To this end, my presentation will be divided into 4 parts. Some of it will overlap what you'd heard earlier, but I'll try and skirt over that. Part 1 will very briefly examine the relevant international law. Part 2 will discuss some of the legal strategies and options available for dealing with settlements at the domestic level in Palestine and in Israel. Part 3 will discuss various legal strategies at the international level, including the domestic level of third states, many of you are represented in this room. And finally, Part 4 will deal with some concluding comments. The relevant law. The relevant international law on civilian settlement in occupied territory is codified in the 1949 Geneva Convention relative to the protection of civilian persons in time of war. Article 49, paragraph 6 of the Convention provides, and I quote, that the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies, end quote. This prohibition is absolute and admits of no exceptions. We know that in international treaty law, sometimes there are exceptions to certain treaty provisions. This is not one of those. It does not admit of any exceptions. A bit of pedigree and history on this. The prohibition is absolute precisely because, and in the words of the ICRC commentary on the provision, quote, it was intended to prevent a practice adopted during the Second World War by certain powers which transferred portions of their own population to occupied territory for the political and racial reasons, or, in order, as they claimed, to colonize those territories. Such transfers worsened the economic situation of the native population and endangered their separate existence as a race. Forgive the archaic language, that's the end of the quote, but you get the point. The Fourth Geneva Convention, as Shahwan rightly pointed out, has a genealogy, and it's directly rooted in the experiences of the civilian population subject to foreign military occupation in Europe in World War II. Thus, the prohibition on deportation of a protected population or transfers of populations to colonize certain territories. A related pair of provisions of the Convention that are not usually cited, though they were earlier today and yesterday, in connection with the absolute prohibition on civilian settlement in Article 49 are Articles 146 and 147 of the Fourth Geneva Convention, which concern penal sanction for the commission of what are called grave breaches, otherwise known in international law as war crimes. Article 147 specifically prescribes the following acts if, quote, committed against persons or property protected by the present convention. 1. Unlawful deportation or transfer. 2. Extensive destruction and appropriation of property, not justified by military necessity and carried out unlawfully and wantonly, end quote. We'd heard earlier that the grave breach regime prohibits settlement of an occupied territory. Technically, that's incorrect. There is no prohibition in the grave breach regime that is in the exact same language of that appears in Article 49. But to the extent that Israel's settlement of occupied Palestine has entailed, in any particular case, the unlawful transfer of one or more members of the protected Palestinian population, or the extensive destruction or appropriation of Palestinian property not justified by military necessity and carried out unlawfully and wantonly, which of course it has, those who have carried out such acts may bear international criminal responsibility under the terms of the Convention. This is precisely because Article 146 of the Convention requires the high contracting parties of the Convention to pass laws that criminalize the commission of grave breaches and also to locate, prosecute, or extradite persons suspected of having committed such grave breaches. The nexus between Article 49 and the grave breach regime in Articles 146 and 147 is therefore of vital import from the standpoint of international accountability mechanisms, as the grave breach regime has to a large extent been incorporated into the domestic legislation of numerous high contracting parties. We shall return to this in a moment when I speak of various options that are available in the territories of high contracting parties at the domestic level. A final piece of relevant law, which we've already covered to a certain extent, is codified in the Rome Statute of the International Criminal Court, to which Palestine has acceded. Article 8 of the Rome Statute enumerates its extensive list of war crimes, including, quote, the transfer directly or indirectly, and this is where Judge Christine's point earlier said that it was broader than that which exists in the 1949 Fourth Geneva Convention, directly or indirectly by the occupying power of parts of its own civilian population into the territory it occupies. We will return to the Rome Statute in a moment. With that said, allow me to turn to the matter of available domestic and international legal strategies, remedies available for addressing the issue of the continued settlement of occupied Palestine. First, legal strategies at the domestic level. These would cover measures local in nature and which contemplate the active involvement of the two parties most directly affected, the State of Israel and the State of Palestine. As the occupying power, compliance with the Fourth Geneva Convention, including the prohibition on civilian settlement, falls to Israel in the first instance. This flows from Israel's general treaty obligations to respect and to ensure respect for the terms of the Convention. I'm quoting there Article 1, Common Article 1 of the Fourth Geneva Convention, which includes, of course, the prohibition on settlements, as well as the requirement that Israel pass laws to criminalize the commission of grave breaches, as just mentioned. The obvious forum for the investigation and adjudication of Israeli violations of the Fourth Geneva Convention is, paradoxically, the Israeli judicial system itself. The problems with this are considerable, however. For one, the system has not been impartial when adjudicating Palestinian claims. Its position on settlements is instructive. As the High Court of Justice has consistently, the Israeli High Court of Justice, has consistently treated that as a matter of policy within the preserve of the legislative and executive branches of government, and therefore not justiciable before the courts. The so-called political question doctrine, which many courts adhere to. In any event, in none of the cases adjudicated by Israeli tribunals have the terms of the Fourth Geneva Convention been applied as a matter of law because of Israel's position that the Convention is non-self-executing, rejecting the Convention's status as a codification of customary international law and therefore binding on it, and therefore requiring of specific legislation in Israel, incorporating it into domestic Israeli law before its courts and tribunals can regard themselves as bound. This is what international lawyers call the dualist approach to the application domestically of international legal obligations. Many of you would be familiar with that. Of course, the reason no such legislation in Israel has been passed is the Israeli government's long-held position that the Fourth Geneva Convention is not, as a matter of law, applicable for the reasons that we've laid out in Article 49. Despite this, however, this position has not been upheld, definitively rejected rather, by the principal organs of the United Nations, including the principal judicial organ in the International Court of Justice, the Security Council, and the General Assembly. As a result, Israel has never taken any of the steps required of it as a high contracting party under Article 146 of the Convention to enact legislation penalizing the commission of grave breaches, to search for and prosecute or extradite individuals suspected of committing or ordering the commission of such grave breaches, or to suppress the commission of other violations of the Convention not amounting to grave breaches. But does this mean that there's no role for the State of Palestine as a high contracting party itself to unilaterally apply the terms of the Convention in Palestine? No, it does not. The possibilities here, in my mind, are twofold. First, despite the historical record of the Israeli judiciary being unwilling to apply the terms of the Convention de jure, Palestine may wish to find ways to support civil society groups to engage in greater levels of test case litigation before the Israeli High Court of Justice. This could be done through provision of more legal aid, either directly or through donors for political reasons, which I'm happy to get into later, as well as legal ones, in cases focused on seeking clear and unequivocal rulings where none already exist of the Israeli court on Israeli policies that violate the Convention. including the prohibition on civilian settlement in occupied territories. The result of such litigation would be to produce either positive results for the Palestinian litigants in question, or more likely, further confirm that Israel is unwilling to subject itself to the scrutiny under the terms of the Convention and to the scrutiny of public international law domestically. Why is this important? Because this would prove useful in undercutting any Israeli argument that the courts, their domestic courts, are competent to hear matters that would otherwise come under the domestic jurisdiction of third states, your good selves, or the jurisdiction of the International Criminal Court, according to the complementarity principle. Many of you would be familiar with that, but the court will not seize jurisdiction under the Rome Statute if a matter is currently sitting before the domestic criminal adjudicative authorities in any particular case. And so once you, and this is also true of many of the criminal and also civil jurisdictions within third states, that third states will be loath to take on the jurisdiction of any particular case if there's a better forum within which, a local remedy that must be exhausted and within which the matter should be dealt with. We'll get back to that in a moment. This means that creative counsel in Palestine can attempt to bring cases before the courts of Palestine also, aimed at giving effect to the legal terms of the convention under the domestic Palestinian laws that may exist as well. So Palestinian litigation, another option would be for Palestinian litigants or counsel to bring cases before Palestinian domestic courts, affirming the convention and applying the convention in respect of Palestinian malfeasance, those Palestinian corporations or legal persons who may either knowingly or unknowingly be engaged with Israel or Israeli contracted parties, private, public, in the maintenance and continuation of the settlement regime. That's another option as well available to the state of Palestine or counsel in Palestine. I'd like now to shift my attention to legal strategies at the international level. These include both independent and collective state activity, as well as global civil society action. These methods of compliance fall into two spheres, those internal to the Fourth Geneva Convention and those external to it. One principal internal mechanism already discussed in relation to Israel is the obligation of all high contracting parties to search for and prosecute or extradite any individual suspected of committing grave breaches and to suppress the commission of other violations of the Convention not amounting to grave breaches. In this sense, Article 146 of the Convention allows for the exercise of universal jurisdiction by the national courts of third state high contracting parties. Universal jurisdiction refers to the authority of domestic courts and international tribunals to prosecute certain crimes regardless of where the offense occurred, the nationality of the perpetrator, or the nationality of the victim. The concept rests upon the rationale that some crimes, such as war crimes, are so universally condemned that they warrant the exercise by any competent national or international judicial authority of criminal jurisdiction over those alleged to have perpetrated them, without regard to the traditional factors upon which criminal jurisdiction is usually based. It is well to recall that the principle of universal jurisdiction was first used by the Supreme Court of Israel in litigation involving Israel's prosecution of Nazi war criminal Adolf Eichmann in 1961. Today, a growing number of Israeli high contracting parties to the Fourth Geneva Convention have begun to enact domestic legislation empowering their courts to invoke universal jurisdiction in accordance with their obligations under Article 146 of the Convention. Accordingly, universal jurisdiction exercised at the national level would seem to hold out one possibility for ensuring compliance with the Fourth Geneva Convention, including, quote, unquote, unlawful deportation or transfer of a protected person or persons, and, quote, the extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly, that may have accompanied settlement, construction, maintenance, expansion. In this regard, increased efforts should be undertaken to study the domestic legislation of key high contracting parties with a view to identify appropriate fora in which to prosecute legal persons who may be engaged in the commission of grave breaches under the Convention. there is a matter of politics here, but also law. So as I say, Article 1, Common Article 1 of the Fourth Geneva Convention requires that all high contracting parties, that is each and every member state, indeed the non-member state in the Holy See and Palestine of the United Nations, who are signatories to the convention, both respect and ensure respect for the terms of the convention. And those terms, ensure respect, are quite important because they impute, they give rise to individual, independent legal obligations on the part of each and every high contracting party. Independent of the actions, political actions, or urgings of the State of Palestine, the Government of Canada, I'm a Canadian national, has an independent legal obligation to ensure respect for the terms of the convention by doing the things that I've laid out, and insofar as it refuses to do, or indeed insofar as other member states and high contracting parties refuse to do, they are in breach of the terms of the convention. So there's no connection between, aside from the factual connection, between the obligations of the high contracting parties and Israel's adherence to the convention. Among mechanisms of compliance that are external to the Fourth Geneva Convention is the International Criminal Court. On the 16th of January 2015, following Palestine's accession to the Rome Statute, the Office of the Prosecutor of the ICC opened a preliminary examination into the situation in Palestine. As noted, the Rome Statute proscribes the transfer, directly or indirectly, by an occupying power of parts of its own civilian population into the territory it occupies, or the deportation or transfer of all or parts of the population of the occupied territory within or outside this territory. In my respectful view, the settlements issue is the single most important potential cause of action that Palestine has under the Rome Statute at present. This is because of the broader impact that the settlements have on the Israel-Palestine conflict, representing an embodiment of Israel's attempts to, at once, illegally acquire territory through the use of force and also frustrate the right of the Palestinian people to exercise self-determination in that territory. These are both peremptory norms of public international law, derogation from which is not permitted, and these are the issues at play in respect of Israel's settlement of occupied Palestine. This is demonstrated, the issue of the illegal annexation through the demographic transformation and colonization of occupied Palestine has been the principal concern of the international community, as demonstrated in its treatment of the matter of Israeli settlements since 1967. Look at Security Council Resolutions 252, 298, 446, 452, 465. Now that the State of Palestine is a party to the Rome Statute, engaging selected high contracting parties who are also parties to the Rome Statute will be an important thing to do in the event any case is brought against Israel or Israeli officials, some of whom may actually be dual nationals of high contracting parties in the future. A related external mechanism is to once again, as we mentioned yesterday, have resort to the International Court of Justice, only this time not to seek a confirmation of the illegality of the settlements as such, but rather to build upon its earlier ruling for a much more important declarative remedy concerning the legality of Israel's prolonged occupation of the State of Palestine. The 2004 advisory opinion on the legal consequences of the construction of a wall in the occupied Palestinian territory was a watershed in the legal history of the question of Palestine. Following a request of the General Assembly, the Court made a number of important rulings, including that the wall was illegal and must be dismantled forthwith, that Israel is under an obligation to terminate its breaches of international law, including the obligation to respect the right of the Palestinian people to self-determination, and so forth. Importantly, the Court affirmed that Israeli settlements in occupied Palestine have been established in breach of international law, and that their position gives expression, to quote the Court, gives expression in loco to the violations that are embodied in the illegality of the settlement regime. It is now 11 years since that fateful ruling. And in the intervening time, with the exception of the establishment of the UN Register of Damage, little effective follow-up has been undertaken to build momentum, and I'm very pleased to hear that the State of Palestine, through Ambassador Mansour, will be looking into these things, to build momentum around the 2004 opinion. The hope would be that this momentum would build around the decision in the same manner that momentum was built around the decisions of the International Court of Justice on Southwest Africa in their advisory opinions between 1950 and 1971, which helped further isolate and encourage apartheid South Africa to reverse course and comply with its relevant international law obligations. It is not too late to do this, and on the basis of the questions first put to us by Professor Dugard, former UN Special Rapporteur for Human Rights in the OPT, in his January 2007 report to the UN Human Rights Council, namely, whether a prolonged occupation that has acquired, quote, some of the characteristics of colonialism and apartheid, end quote, continues to be a lawful regime. And if not, what are the legal consequences of that for Israel, Palestine, and third states? We spoke very briefly yesterday and earlier today about potential for economic sanctions, but of course there is great potential within the United Nations to perform that under the Charter. We have some difficulties politically with taking decisions at the Security Council level under Chapter 7 to impose economic sanctions on Israel for its violations of the Fourth Geneva Convention by virtue of the presence of a permanent member. But this does not mean that actions cannot be taken under the Uniting for Peace resolution formula, which the State of Palestine has done in the past. So there's another option to seek redress through declarations and resolutions of the General Assembly expressing the political will of member states, who then would be able to take decisions on their own vis-a-vis economic sanctions. I should like to conclude by noting the important role of civil society in all of this. Between the increasingly intransigent actions of successive Israeli governments in recent years, the ever-desperate situation faced by the Palestinian people, who either remain in exile or under attack in their own land, and the modern advances in information technology that have, for the first time, allowed all of this to be witnessed the world over, unfettered and virtually in real time, it seems fair to observe that we're living in a moment that holds out unique possibilities for progressive change in ways hitherto thought impossible. For all the difficulties that lay ahead, no one can deny the unprecedented successes of the boycott, divestment, and sanctions movement in exposing the moral decay and hypocrisy at the heart of the status quo. It is a sign of the times when today Israel can no longer count on the automatic support of Western liberal lefties, as we say, but rather draws its greatest support from the most reactionary and right-wing amongst us, and is increasingly relying upon old, specious, and tellingly futile canards and ad hominem, where it is unable to answer its critics on the merits. As history has shown, such shifts have always played a pivotal role in fostering legal strategies directed at the great moral questions of the day, be it the end of slavery, the struggle for universal suffrage, or the South African anti-apartheid movement. It is respectfully submitted that the Palestinian freedom struggle is no different, and that any legal strategies adopted in furtherance of that struggle, including in respect of the settlements, will ultimately be made possible by changes in public policy at both the international and domestic levels, hastened by the work of civil society as an embodiment of a progressive and humanist public international politics and consciousness. With that, I would like to thank you for overextending my time, and I look forward to discussion with you all. Thank you.